Наталья Владимировна, я вас представлю тогда?
Да, конечно, Галина Михайловна.
Да. Dear students, dear friends, dear colleagues, I want to introduce our Vice Dean Natalia Kozlova, who wants just to welcome all of the participants of the conference, and then we'll start our work. Наталья Владимировна, пожалуйста.
Здравствуйте, дорогие коллеги. Разрешите мне, как всегда, от имени юридического факультета МГУ говорить по-русски и приветствовать всех наших участников. Галина Михайловна, вы будете переводить синхронно?
Да, наверное, буду переводить синхронно, да. Наталья Владимировна welcomes all of the participants of the conference from, on behalf of the Moscow State University.
Очень приятно вас всех видеть. К сожалению, в силу сложившейся ситуации мы не имеем счастья общаться лично, но мы надеемся, что этот формат мы сможем позаимствовать в дальнейшем. И те участники, которые не могут к нам присоединиться объективно, будут продолжать с нами участвовать посредством новых средств связи, а остальные приедут к нам лично на следующий год.
It's a great pleasure to see all of you here. Unfortunately, this year we were not able to see each other in live. We will work online and we will continue working online, but we very much hope that next year we'll meet personally here in Moscow.
Большое спасибо, что вы проявляете такой интерес и к нашему юридическому факультету, и к тем проблемам, которые мы ставим в рамках нашей юридической недели и наших научных конференций.
Thank you very much for your interest to the Law School of the Moscow State University, for your interest to the problems which are arising in our legislation.
Религия всегда играла важную роль в нашей жизни, в жизни каждого человека и всего общества, и всегда была источником, в том числе и права. Поэтому для юристов очень важно понимать вот эти истоки общечеловеческих ценностей, которые заложены в каждой религии.
Religion is a very important thing, and for each of us, it's a very important to understand the values which religion contents in and is bringing to each of us.
И мы надеемся, что, несмотря на разницу в деталях наших верований, всех нас объединяет любовь к Господу, любовь к Богу и осознание вот этих общечеловеческих ценностей, общечеловеческой морали, нравственных ориентиров, понимание добра, справедливости, которые заложены в каждом человеке.
And in spite of the differences between the religion, we all are following the main values which are in different religions. And it's the love to each other, love to the God, and love to the main values of the humanity.
И мы надеемся, что наши встречи помогут нам сделать этот мир лучше, и каждого из нас сделают лучше. Давайте любить друг друга, давайте стремиться к совершенству, к счастью. Путь этот бесконечный, но если все мы будем прилагать к этому усилия, мир обязательно изменится к лучшему.
And we very much hope that the meetings like this and conferences like this will make us better. Let us do the world better and all the values better and follow the best values of the world and be together.
Я желаю вам всем здоровья, счастья, творческих успехов, удачи во всех ваших делах и всего вам самого доброго и продолжения участия в наших мероприятиях, в наших конференциях. Большое спасибо нашему организатору, нашей дорогой Галине Михайловне, которая нас вдохновляет и каждый год собирает. Спасибо вам большое, дорогие коллеги, будьте все здоровы.
Спасибо большое. Natalia Kozlova wished to all of us, first of all, be healthy, and she wishes success to our discussion today and to all of us. And she wants us to gather together often and be together. And she says thanks to me for arranging this meeting.
Спасибо большое. Успехов вам, дорогие коллеги.
Спасибо. Спасибо большое. Please pay attention on the view for her room. You can see the main building of the Moscow State University, which is magnificent. You see the view, and the Moscow State University, the one of the Seven Sisters, which is very beautiful, especially when it's evening. So I hope very much that some days we'll gather here, get together, and go to this building. We have interesting excursions there. We'll show you around. Спасибо большое, Наталья Владимировна.
Галина Михайловна, скажите, что мы зовем его храм науки.
We called it as a, как сказать, храм науки, Church of a Knowledge. We charge it as the Church of, but not a regular church, but the Church of
Science.
Church of Science. Church of Science, yeah. Я надеюсь, это не богохульство в данном случае. Спасибо большое. Да. Спасибо большое, Наталья Владимировна. I want to introduce to Natalia Kozlova and to other participants our guest today. And I introduce you by coming in. First was Lina Papadopoulou. She's an associate professor of the... Lina, maybe you'll introduce yourself. It will be easier.
Спасибо большое. Thank you very much for having me here, for the invitation. I'm very glad to be with you. I am an associate professor of constitutional law based in Thessaloniki in Greece. So this is northern Greece. And I teach constitutional law, and one of my research interests is also the church and state relationships and the freedom of religion. And I'm also the academic coordinator of Jean Monnet Center of Excellence on European constitutionalism and religions. So thanks again. I'm glad to be here with you.
Thank you very much. The next was Anton Kaniewski. Anton, please.
Hello, everyone. I'm proud to be an alumni of Moscow State University, and was happy to participate in to make some efforts to open this center, which Professor Davidian heads, is the head of the center. And I have a PhD in law from Institute of Law and State in Russia, invited lecturer in High School of Economics in Moscow, and practicing in Israel, in Jerusalem. Thank you.
Thank you, Anton. Kathryn?
Yes, good morning. My name is Kathryn Chan. As I said, I'm an associate professor at the University of Victoria Faculty of Law, and I teach and research in the areas of constitutional law and administrative law. I teach a course on law and religion, and also nonprofit law.
Thank you very much. And Mark?
Большое привет, большое спасибо. Thank you very much for having me. Thank you, Professor Davidian. I'm Mark Movsesian. I'm a professor at St. John's University Law School in New York City. I'm also the co-director of the Center for Law and Religion at St. John's. And I'm delighted to be here. This is my second time at Lomonosov Moscow State University. I also spoke in the spring. And I want to thank Professor Davidian again. I'm delighted to be here. Thank you for having me.
Thank you very much. We also have Dr. Barre, Xavier Barre. He's from France. Unfortunately, he had the problem with his health. Now he's in an ambulance. He sent me his papers, and I'll share it with you, or maybe I'll read it, or maybe he'll be back. I don't know. And we are expecting to have Andrea Pin from the University of Padua. He'll be shortly with us. Unfortunately, there were some other problems too, and he just let us know that he'll be soon with us and speak. Now, let us start with the roundtable. Today, we are discussing with you the problems of the God, law, and the Constitution. And we gathered, especially here, people from different countries in order to see how everything is working in different countries and what experience our colleagues have, and they'll share with us their experience and the knowledge about the God, law, and the constitution, and how the law and religion is working in different countries. There was a big problem. We don't know how to start. I was thinking that maybe we'll start in alphabet by alphabet, but now I decided that we'll start by coming in. So first was Lina. We'll let her start with her presentation, and then Anton, Kathryn, Mark, and I hope that I'll be the last one, because we have a rule in Russia that the hosts usually are the last one. So I'll be very glad to give the floor to Lina Papadopoulou, and she'll be speaking about the issues which are rising in a country with dominate religion in Greece. Please, Lina.
Thank you very much, Professor Davidian. This is against the legal safety, because I didn't know that coming first is means also speaking first. Oh, okay. Greece is, well, I think it's an interesting case. Let's start, first of all, to have a look on the big picture, let's say. According to theory, there are three different models, constitutional models or legal models, concerning the church and state relationships. So the first one is the state-church system. In those countries where we have a church very closely linked with the state, no matter how, what the name is, it might be called state church or national church or an established church or folk church. And here in Greece, we call it actually a prevailing religion. So Greece does fall under this model, together with England, Denmark, and also Finland and Malta and Bulgaria. Then, of course, we have the other side, the separation system. We know that here in Europe, France is the most salient example of this, but also Netherlands and to some extent also Ireland. And then, of course, we have in between the hybrid systems. So all the other more or less states like Italy, Germany, Austria, etc., fall somewhere in between. So in Greece, we don't call the church state church, but as I said before, we do call the religion of the Greek Orthodox Christian Church, the Church of Christ, the Orthodox Church of Christ, we call it the prevailing religion. And this is guaranteed by Article 3 of the Greek Constitution. So already an article which is situated in the department with the basic articles of the Greek Constitution. This also is significant. As a matter of fact, next year in 2021, we celebrate 200 years after the revolution against the Ottoman Empire, and the first Greek state was constituted in 1830, and the first Greek constitution was in 1822. So as a matter of fact, back then, 200 years ago, it was actually the Christian religion that distinguished those who could stay in the newly established Greek state and those who should actually leave, if not murdered sometimes by the revolutionaries. So it was not a matter of, let's say, blood, because how can you examine blood? It was a matter of religion. So even people who were established in what became the Greek state for centuries, they had to leave because they had converted earlier to Islam. So the Greek state from the beginning was built on the basis of Christendom, and actually also people who came from the rest of Europe to establish themselves in Greece, as long as they were Christians, not only Orthodox Christians, but Christians altogether, they could be Greeks. They could acquire the Greek citizenship. So the Greek citizenship, historically speaking, from the beginning was very closely linked with the Christian religion. And this is something we, until now, 2 centuries later, we have inherited, so to say. And as a matter of fact, even the heading of the Constitution, it's not actually a preamble. It's not correct to say that it is a preamble. There is not a preamble in the Constitution, but there is a heading just after the name Constitution of Greece. And this heading says, in the name of the Holy and consubstantial and indivisible Trinity. So you understand that this is a confession of faith by the Constitution itself. And then Article 3, as I said, included in the basic articles. First of all, we have the article on constitutional democracy and parliamentary democracy, as a matter of fact. Then we have the article on human dignity and the openness of Greek state to international arena. And then we have Article 3. And Article 3 in previous constitutions used to be Article 1. And this Article 3 nowadays stipulates that the prevailing religion in Greece is that of the Eastern Orthodox Church of Christ. And as a matter of fact, the same article continues by another religious confession. It says, the Orthodox Church of Greece, acknowledging our Lord Jesus Christ as its head. So it's our, Jesus Christ is our Lord. So the Constitution itself expresses itself. It says that this Jesus Christ is actually our Lord, something that could be very much challenged as to the extent that it covers all Greeks. If one thinks that 200 years after the revolution, nowadays there are citizens of Greece, not speaking about immigrants, of course, much more, but even, of course, citizens of Greece who are not Christians, who are not Orthodox Christians, who might be Muslims. We have a Muslim minority in Western Thrace. And they might be agnosticists, they might be Catholics or Buddhists or atheists or anything else. So it is a bit problematic, if you ask me. So the theory actually tried to relativize this kind of confirmation of a prevailing religion. The theory, allow me to say, the liberal constitutional theory tried to undermine, let's say, the substance of this article and say, well, you know what, when the Constitution say the prevailing religion, this is more something like a description, because most Greeks are Orthodox Christians, and they are Orthodox Christians because we exercise the baby baptism. So everybody who is born in a Christian family, if not everybody, but 98% of the people who are born in a Christian family, they are baptized as Orthodox Christians, of course, against their will, because they're babies, they can't express themselves. So the vast majority of Greek citizens are Orthodox Christians indeed. Nevertheless, the liberal constitutional theory insists that actually we need to read Article 3 in combination with Article 13 of the Constitution, which is the article that guarantees religious freedom. So Article 13 is a liberal article. It guarantees not only the tolerance of other religions, not only the tolerance of of persons who belong to other religions, but religious freedom, which means that it includes also religious equality. And this is very important to remember. So the interpretation of those two articles in combination, the one with another, gives a picture that is more liberal than actually only Article 3. And as a matter of fact, we all know, most of us are legal theorists here, or we study law, or we are lawyers, etc. So we know that when we interpret combination of provisions, we tend to underline that provision that helps us come to the conclusion that we favor. So there are two different ways how to interpret the Greek constitution: the liberal way, which poses more weight to Article 13, which is the right to religious freedom and religious equality, and the more conservative way of interpreting the Constitution that puts more weight to the subheading in the name of the Holy Trinity, and Article 3, which is the prevailing religion. And as a matter of fact, we have had recently, quite recently, in the last 3-4 years, we had a number of decisions by our Supreme Administrative Court, which is called the Council of State, named after its French counterpart. In Greece, I have to say, we do not have a constitutional court. So there's no constitutional court. So something that resembles, let's say, a constitutional court, or sometimes plays the role that a constitutional court would play, is our Council of State, which is the Supreme Administrative Court. So we have had a number of very conservative decisions by the Council of State lately that had to do with the teaching of religion at schools. So the teaching of religion at schools is heavily Orthodox Christian. So the books were written as Christian Orthodox books, and they were of catechetical nature. So the government before the one now, they had replaced the books, and they changed a bit, not a big part of the books, but let's say something like 20% of the books, so that the books also spoke about other religions. And that was a slight change. I mean, it did not really change the catechetical nature of the religion course at school. Nevertheless, the Council of State adjudicated on this change, and they found this change unconstitutional, because they said that everybody in Greece should actually learn about their own religion. So because most students, most pupils are Christian Orthodox, as I said before, they're baptized without asking them. So they're obliged actually to learn about the Greek, the Christian Orthodox Church dogmas. And when it comes to minorities, if somebody is of another religion, then of course he or she can be exempted, and he or she is not obliged, of course, to follow the course. So this decision, which according to my opinion is a very negative one, because it actually brings into Greek schools a kind of segregation like the ones we had in the USA, with the segregation between schools for Black and white people, students, right? They said, okay, we are equal, but you should be segregated, separated. So it reminds me of that era, unfortunately. So I find it very problematic. So this is the situation. Of course, there is a lot of critique on those rulings by, as I said before, liberal constitutional theorists who say that this is not the right way to interpret the Constitution, because religious liberty also means that you should not be obliged to reveal your personal religious beliefs. And now we have, I mean, this liberal understanding, this liberal reading of the Constitution does have an ally. And this ally is the European Court of Human Rights, based in Strasbourg. So as a matter of fact, in the last, let's say, 20, 30 years approximately, there have been a lot of changes to the positive direction in favor of religious freedom and in favor of religious equality in Greece because of the jurisprudence of Strasbourg, of the European Court of Human Rights. So a lot of religious minorities who did not enjoy the same extent of liberty like the majority, the Orthodox Christians, they did acquire more rights, more liberty, more freedom because of Strasbourg. And that is a very good factor, if you ask me, because although Greece is part of the European Union and it has been part of the Council of Europe since democracy came back after the dictatorship we had for 7 years between 67 and 74. Nevertheless, we needed, unfortunately, it's a shame maybe, but we needed Strasbourg in order for religious minorities to gain more liberty and more freedom and to feel really equal with the majority of Christian Orthodox people in Greece. So there is a number, I'm sure you are acquainted with a lot of decisions that were of somebody against Greece versus Greece. We have done a lot of headlines when it comes to the jurisprudence of the Strasbourg Court concerning religious freedom. As a matter of fact, Greece is one of the countries with the most violations, which has most violations, I think one of the three countries in the Council of Europe with violations in the field of religious freedom in the last, let's say, 20 years in this century, in the 21st century. So there was a lot of progress, but there's always this tension. And this tension, and this is the conclusion to which I would like to come, and then we can discuss further if you want. This tension does not only have to do, as I said before, with the Constitution and with law and what law says. This tension, unfortunately, has to do more with politics. And I say that because one thing is the black letter of the Constitution, and another thing is actually how this Constitution is being interpreted. But there is another dimension, and the other dimension is how politicians, how political parties, the political forces which are prevailing in Greece, how they operationalize sometimes, they use or abuse sometimes the Christian sentiments of the majority of Greek citizens in order for them to gain support. So I think that in a system like ours, which, as we call, it's a state law rule, which means that the state actually decides a lot of things about the church. There is also a hidden influence, an influence behind the table or below the table, okay, under the radar maybe sometimes, but sometimes also very visible influence by the church on politicians, on ministers of, actually our Minister of Education is at the same time Minister of Religion. That is something very telling, maybe in symbolical terms. So I'm afraid that no matter what the church itself says, and the Greek Orthodox Church is in comparison to other churches in Europe, especially, of course, in comparison with the Protestant churches, the evangelical, etc., which are more progressive, the Greek Orthodox Church is rather a conservative one. But no matter what the church says, the last decision is the decision of the legislator, of the democratically legitimated legislator, of the political parties, of the politicians, of the prime minister, of the members of parliament, etc. So what is more telling about the situation beyond the black letter of the Constitution and the laws is actually how the internal feelings, which are 100% respected by the majority of Greek people, is sometimes abused by the politicians for their political goals. And this keeps Greece, in a lot of cases, this keeps Greece behind, maybe, when compared to other societies. And a very telling example is, for example, the Irish society, which is supposed to be very Catholic and conservative. Nevertheless, we have had two very important referenda lately in Ireland. The one on legalization of abortion and the other one on legalization of same-sex marriage. And this shows that societies actually do have progresses. But I think that this also had to do with the stance of the Irish politicians, something which is not the case with Greece. So thank you very much for your patience and your attention, and remain at your disposal for any questions you might have.
Oh, thank you very much, Lina. I just want to discuss with you how we will work. I'll suggest maybe we will first listen to all the reports, to the presentations, and then ask questions, or you want to ask questions after each presentation. What do you think?
I think it's better to listen everybody, and then maybe some questions will be combining different elements of different.
Okay, good. That was my idea. Thank you very much. So the second who came in was Anton. I'm sorry. It was a very good idea. Now I found out, in order not to insult somebody. Anton, are you here?
Yes.
Please, Anton, start, and then Kathryn, she'll be
Okay.
the third. Yeah.
Okay. I wonder if I'll try to do some. 1 second, some share screen. I'll just check if it's, yeah. Yeah, I guess I'm now screen sharing. Am I?
Yes.
Perfect. Okay. Now, let me start with a kind of general introductory remark. The subject is God, law, and constitution. And I think in this context, we are talking, in a sense, about reference to God, using the name of God, mentioning this word in legal texts. So
can you please start the presentation? Just start the presentation, because now we see only your computer.
I'm screen sharing.
Yes, you are sharing the screen, but you are sharing the screen of your computer, and we can't see the presentation. Just open the.
Now it is?
Yes.
Oh, perfect. Thank you. Okay. So in fact, in Talmudic sources and rabbinic sources, this issue of name in general and divine name in particular is discussed extensively, and I think it would be appropriate to add to our discussion the dimension of what does it mean in general, the concept of name, and as applied to divinity, and then how these references affect texts where they appear. So the concept of name, this is the first thing. When in general, even when we are talking about two human individuals, the fact that another has a name and I can address him by this name, as compared to a situation that when I can in no way address a person, might illustrate that the fact that the name exists and I can use it, this permits me to stress the importance of existence of the other. I'm in some Sartrean concept, right? Une autre, c'est un scandale. So, in other words, when I use someone's name, this means that this person starts to really exist in my world. When otherwise, another might stay unnoticed. So, if I can address another, and then I can, by this very fact and by this very act of addressing another by name, I initiate a kind of relationship, and this might cause, in response, the other to relate to me in a more personal way than the other would relate if I did not address him at all. Now, these general considerations are indeed applied to relations between person and divinity. And so let's take one example to get all this a little bit down to earth, and then we'll get back for a small generalization. So this concept of using extensively a name of divinity is discussed in the context of the history of the early history of Abraham, who made attempts, and in fact his whole life was in a sense an attempt to make the general public in his times informed about the fact that God created the world and that he is constantly renewing the creation. And what is interesting for us is that the commentary states that the result of his educational activities was that people started to mention the name of God. And what is even more, I think, meaningful for us as people who are trying to analyze the problem of authority and how it appears in thinking and in legal thinking, the very fact that people started to mention the name of God in mundane activities led to the fact that it became possible to call God himself not only the King of heavens, but also the King of the earth. This is a very, it is, I think, for a normal person, this might sound very strange. Why in general it's relevant to call something as transcendental as God himself King of the earth. But this can be understood in from the point of view that his kingship, the fact that he is the idea that he can be called the king in our earthly terms, it's an attempt to present the fact that he wants to be accepted and he is really interested in the service of people, and this is the purpose for which he created the humanity. And since if we let ourselves to think a little bit about a theory that he created humanity for servitude, then it might become more clear why indeed it's absolutely appropriate to use a mundane term king and kingship to him. Now, so we said already that I think the main problem that might serve as a basis for putting these words, God, law, and constitution, in one line is the problem of authority. And I would like to ask a general question, with your permission. What's the purpose and what's the sense of mentioning God in the Constitution? And in the most specific terms, is reference to a secular authority, like we the people, or whatever other authority in general is mentioned as the final as the source of law, let's say. So if whatever authority is mentioned as highest authority without making reference to the existence of even higher recognition of absolute authority of God. And we have legal dimensions of this question in the main code of Jewish law, written by Maimonides a little bit less than 1,000 years ago, where Maimonides talks about not only about Jewish specific Jewish commandments addressed to all Jewish people, but also he's talking there about universal norms that are obligatory from the point of view of Judaism, at least, for all the humanity. And there are a few clearly legal from any point of view norms among these 7 commandments. You can see prohibitions against murder and theft, and also we have the command to establish laws and courts of justice. So let me stress that from the point of view of Jewish law, there is a universal divine commandment, not a natural law commandment, which requires from all nations to establish laws and courts of justice. Now, Maimonides doesn't limit his analysis and discussion of and explanation of these concepts just by making a list that you have just seen, but he brings up a very particular idea. He makes very high requirements, very difficult requirements for how the commandments, universal commandments and even legal commandments, have to be realized. What should be the basis of the commandments when they are practically implemented? So let me read another piece of his code. So anyone who accepts upon himself the fulfillment of the so-called no-hide commandments, right? So we are talking about 7 commandments that have been passed to Adam and then to Noah, the person for whom all the humanity, according to the Bible, started. So these universal commandments are called no-hide commandments. I'll just make one step back. Just you see above no-hide code. So anyone who accepts upon himself the fulfillment of these commandments and is precise in their observance is considered the pious among the nations. But now there is a very interesting idea. There is a requirement of why a person fulfills these norms that otherwise might be seen as basic natural law requirements, basic natural law norms. So Maimonides writes in the 2nd paragraph that a person has to accept and fulfill the commandments only because and on the basis of the fact that they come from above. Moreover, Maimonides even makes clear requirement on how one has to, what one has to think about the precise source where these commandments and when these commandments were passed to the humanity. As we said, according to the Talmud, basic universal commandments were passed to Adam, the first man on earth, and then again to Noah. Maybe it was even added one specific commandment to Noah, which is not relevant to our discussion right now. But still, according to Maimonides, the fact that these commandments were passed to Adam and Noah is not the right fact, as is not the source of authority, the precise source of authority of these commandments. In some Kelsenian sense, the basic norm for universal commandments is connected, is kind of Kelsenian version of the Sinaic revelation, not of early revelations. According to the concept of Maimonides, Sinaic revelation contained information about previous revelations, but required from those who were the recipients of these revelation, of that message, required from them to abide by the Sinaitic revelation alone, even when it refers to Noahide code. So in this sense, the Sinaitic revelation is considered kind of an event of, indeed, of universal significance, not only for Jewish people, even from the point of view of Talmud itself, right? We are not talking about other religions now. And now we come to the most challenging paragraph, the last paragraph of Maimonides' approach to this issue. Maimonides openly discusses here what a person who does implement the norms that seem to resemble, even resembled 100%, the Noahide code, but abides by these norms only because his intellect compels him to do so. In other words, the Maimonides posits here a question: what about a person who does implement all these, who lives up to the high norm required by the Noahide code, required by the universal commandments, with one slight exception? He lives up to this, but because of his intellect compels him to live so, not because he recognizes higher authority, which is above the intellect. And here there are two versions of his handwriting, one more authoritative, the other less authoritative. And the universally accepted version is that a person who does abide by the norms without accepting the divine authority, not only is not pious among the nations, which could be understood, but even is not of their wise ones. So Rambam even denies possibility to call a natural law, sincere natural law philosopher, I would say, a wise person. Why? He thinks, it seems to that it could be explained that he strongly rejects natural law philosophy as an idea that might impose upon people absolute imperative. It can, natural law philosophy might contain good ideas from his point of view. It seems, right? He didn't write this, but that's the explanation that is generally accepted. That Maimonides does let natural law philosophy give recommendations, but denies possibility that it might contain absolute imperatives. And it seems that Maimonides supposes that philosophers who call recommendations imperatives miss some modalities, miss the idea of proper modalities. Still, I have to note that there is another version, and indeed we have two handwritings where it's written that they are not pious, but indeed they are wise. And the problem is that the difference in Hebrew is only in one letter. Okay. Now let's. I think
Anton, I'm sorry, but you ran out of the time. Sorry. Can you just come to the conclusion?
Da. So what I wanted to bring up here, that when there is this that the fact that there is or is there is no this explicit reference is a question of whether it can be analyzed from the point of view how it posits itself from the point of view of this Noahide code, and this permits us to apply additional instrument to the analysis of this question, subject of our discussion. Thank you.
Thank you very much. Can you please switch off the screen? Okay. And Kathryn?
Yes. Can you hear me?
Yeah, yes, you are the next one, please.
Okay, great. I'm going to also share my screen.
Dear participants, please listen and prepare questions, interesting questions for discussion. Please, Kathryn.
All right. Well, I'm just setting my timer here so I don't go too long. And I will share my screen with you. The sun is just coming up on the West Coast here, so this is good news.
Yeah.
And let me just see if this is this working?
Yes, very well.
Okay, perfect. All right, so good morning again, and thanks very much for having me. I just wanted to take my few minutes this morning and give a little bit of an overview of
you have from 15 to 20 minutes. So.
Okay, and give an overview of Canadian constitutional law, the place of God and the place of religious freedom in it, and then talk about a couple of recent decisions of our Supreme Court, our highest court, that may be of interest. So I had kind of thought that I was going to follow Mark and juxtapose our position to that of the United States, but as a Canadian, I'm very pleased here to be going first, and he can compare himself to us. Right, I'm sitting in Canada on the unceded territories of the Lekwungen-speaking peoples, right, in a very big nation that was colonized, starting in the 1600s, more or less, right, 1700s, by the English and the French. And our constitutional tradition reflects a lot of that history. Okay, so it's different than the United States. We've historically had a closer relationship, I would say, overall between ecclesiastical and secular authorities, less of a strict kind of wall of separation, and no establishment clause, anti-establishment clause specifically in any of our constitutional documents. Our initial written constitutional document, the Constitution Act 1867, didn't contain an explicit guarantee of religious freedom, but religious freedom has always played an important role in the constitutional relationship between the French and English settler communities here. And so in the 17 and 1800s, we saw quite strong guarantees, for example, of religious liberty for the French Catholic-speaking minorities under the Treaty of Paris, under the Quebec Act 1774. And then, as you see here, under the Constitution Act 1867, specific protection of minority religious educational rights. So for the minority Catholic population in Ontario, which was mostly Protestant, and the minority Protestant population in Quebec. And that's been a source of litigation. Can we stretch that now further in the 21st century? And the courts have largely said no. Okay, but it's always been in the background. And of course, it's played a very different role. Religion and religious freedom, or lack of religious freedom, one would say, more in the historical constitutional relationship between the Canadian state and Indigenous peoples, right? In that context, there is a long history of, I would say, suppression of religious practices that extended well into the 20th century. Okay, so that needs to be carried alongside, and we'll see has come up again recently. In 1982, Canada got a Canadian Charter of Rights and Freedoms. So we now have a written constitutional document that's about 35 years old, and it contains, I would say, 4 provisions that are particularly important to the discussion of religious freedom. Okay, so we have a fundamental freedoms section that includes freedom of conscience and religion. Those are grouped together, and there's ongoing conversation about whether and how freedom of conscience is different or the same as freedom of religion. We also have a preamble that mentions God, so that says, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. So I was interested in Lina's discussion about how, liberal theorists have kind of tried to undermine that or make it consistent with their beliefs in the Greek context, or something that seems even a little bit stronger. In Canada, I would say we're not even that kind. So there's a judge in the jurisdiction where I am who has called this a dead letter of Canadian law. It's largely ignored, although occasionally people ask questions about, well, it must mean something, right? I mean, we don't give up, we all accept that it's founded on the rule of law, right? But it's kind of a question that lingers in the background. And then 2 other important constitutional provisions. One is that we have a justification clause in our Charter of Rights and Freedoms, and that's section 1, right, which allows government to, once a violation of religious freedom has been established in court, the onus shifts to government basically to say that whatever that thing is that's limiting religious freedom is reasonably justified because it pursues basically a pressing public purpose in a proportional way. Okay, and most of our religious freedom litigation actually, the substance of it takes place under that section 1 analysis. So it's quite a low barrier to establish a section 2 violation, and a higher barrier to say that the government action has not been justified. We have a provision that says that we should interpret the Charter in a way that's consistent with our multicultural heritage, right? Something that is a big part of Canada's identity. We, of course, have now many, many immigrants from many, many countries. And the one I forgot to put there is we also have a notwithstanding clause that applies to section 2, which allows the government to say, notwithstanding this protection, we're going to pass this law anyway. It lasts for 5 years, and it has been invoked most recently in this context by the Quebec government with regard to the limitations on the wearing of headscarves and other visible religious symbols by members of the public service. So we have parallels with some of the debates going on in France, in Quebec. Here, it's pretty much universally regarded to be that would be a violation of religious freedom, but it's been right now defended by the government under Section 33, and there's some interesting litigation going on around that. So these are some of the issues I think that are important or that are talked about in Canada right now. So, you know, we have kind of an ongoing issue, I would say, about how it is that the courts should characterize and maybe even more weigh the importance of specific religious beliefs and practices while still staying neutral, secular, right? And we've seen it especially in the context recently of Indigenous spirituality claims. And I'll come to one of those in a second. We have a consideration about competing rights, right? How you measure, and I think this is common to many countries, how the court should balance the protection of religious freedom against other rights, and I would say in particular, equality interests in Canada. And we have a question, an ongoing question that has been a big part of the discussion, I think, in the United States that we haven't yet answered, about whether religious institutions and corporations that have a religious character enjoy religious freedom, and if they do so in their own right. So that is still a lingering issue in Canada. And then I would say also increasingly a trend that's interesting is I think that the cases tend to stem from executive action rather than actual challenges to legislation, and that's brought about some of its own challenges. So let me just talk quickly about two cases from the last 2 or 3 years that might be of interest. This is kind of a fuzzy picture, but this is what the Ktunaxa people of Canada, one of our First Nations, call Katmuk. It is part of the traditional territory of the Ktunaxa First Nation, which covers approximately 70,000 square kilometers in the southeast of the province where I sit. So if you can't picture what that is, that's almost double the size of Switzerland that the Ktunaxa Nation consider to be within their traditional territories. So very large swath of land, very, very beautiful land. And this case arose when the government of British Columbia decided to approve the construction of a ski resort in this region. It is, of course, I shouldn't say of course, it is Crown land, though it is claimed by the Ktunaxa as part of their traditional territories. So maybe like a very North American set of facts here where the government decides to build a ski resort in a region that was one of the most sacred sites within these lands to the Ktunaxa. The Ktunaxa believed that the proposed resorts would drive the grizzly bear spirit from the territory. So the grizzly bear spirit was an important spiritual presence to them, and that this would deprive them of access to that presence and to all the ceremonies and beliefs that went with it. And they took the position that, you know, the grizzly bear spirit simply couldn't be in a place where people were overnighting, right, and recreating, and thus would vacate that territory. And so the minister decides to approve the ski resort, and it goes up to our, eventually up to our highest court. Okay, so just a couple of interesting points from this case. That's not too important, right? First is, like, again, as I was saying, this is executive action. So that we have a statute that allows the minister to dispose of certain empty land in the public interest, right? Which is a very obviously broad discretion that's given to the minister under the statute. And pursuant to that discretion, the minister approves this year-round ski resort in Katmuk. Okay, and so that brings up some of the issues that we're having around how it is that the courts should undertake this balance and this proportionality exercise around religious freedom cases. And we have a case called Dore from about 7 years ago, where the Supreme Court of Canada, we have basically a fairly rigid doctrinal test for justifying legislation that violates a charter right, okay, with a fair amount of structured steps. And the question arose, well, how do we do this when it's actually an exercise of executive discretion? And the Supreme Court of Canada set out this rather more loose test, which is just, well, the court has to ask if the administrative decision maker has properly balanced the charter values, and sometimes they say charter values, sometimes they say charter rights, with their statutory objectives. Okay, so this is a proportionality exercise. I think this is a concept, I don't know if it's the same in how many countries, right? But in a lot of jurisdictions in rights jurisprudence, balancing the severity of the interference with the right, with the statutory objectives. Okay, and so it ends up looking, I think, a little bit like this. It's almost this simple, right? That the court has to decide which of these things is weightier, or how they should be balanced. Okay, and so when you have this kind of exercise, I think it becomes really important to be able to kind of pin down what the charter right is, or what the religious freedom, what the exercise of religious freedom is that's being claimed in particular, and how important that right is, how important that exercise of religious freedom is. Okay, in this case, the Tanaha did not even get there. So in this case, the court found, the majority found, and there was a split on this, that there was no religious freedom infringement. And this was a really interesting, and most people think very problematic way they got there. What the court said, what the majority said, was that the charter protects the freedom to worship, but not the spiritual focal point of worship. And here, what the Tanaha were trying to get the court to protect was not their freedom to worship the grizzly bear spirit, but actually the grizzly bear spirit itself, and that they couldn't do that. And so, I mean, we can maybe talk about that later, right? It's problematic, I think, on a number of levels, including that it has a very particular emphasis on Indigenous peoples who tend to have land-based practices. So the second and only other case I wanted to talk about briefly is a case called Trinity Western University and Law Society of British Columbia. And this may be of interest to those of you who are law students, because it involved a private Christian university in British Columbia that wanted to start a new law school. And the big barrier to that was that the school, the broader private Christian university, had a community covenant that prohibited certain activities, including same-sex sexual intimacy. Okay, and so this became a very big case in Canada. It was probably the closest we've had to a real culture war here, I would say, in the courts in the last decade. We have provincial law societies, and they all make their own decisions. 3 of them decided not to accredit this particular law program, which meant that you could go there as a law student, but you couldn't automatically become a lawyer afterwards, right? Which kind of reduced the appeal of the program, as you can imagine. And again, right, it's not important to read all this text, but it's executive action. Okay, so there's a grant of power to the Law Society of British Columbia, and under that grant of power, they are deciding whether or not this faculty of law should be approved. Okay, so once again, it comes down to this balancing exercise, right? And I would say fairly broad terms. The decision maker has to, in our law, balance the interference with the right of religious freedom that's at stake here with the statutory objectives of the Law Society, which included protecting the public interest in the administration of justice. And that was understood to encompass legitimately a concern for the diversity of the legal profession and of equal access to the legal profession, okay, which was impacted here. And so I just will perhaps end here, but again, you get the case split 4 ways, the court split 4 ways. They had a lot of trouble with it. And I think part of the trouble was they had a lot of trouble nailing down exactly what was the exercise of religious freedom that was at stake here, and whose it was, and how serious that infringement was. So here on this screen, you see 4 different articulations of what's at stake, right? So the majority found it's a belief that studying in a community defined by religious beliefs contributes to their spiritual development. And by there, they seem to mean a kind of amorphous group of students, okay? Someone else said it's the members' belief that they must be in an institution with others who share their practices on sexual relations, okay? Right, so briefly, there was little agreement on exactly what was at stake. And so ultimately the court found that there was a limit on religious freedom, but it wasn't that important a limit on religious freedom, or that weighty a limit. And thus fulfilling the statutory objectives was fair to choose that instead. Okay, and I suppose I'll end with this point, because my view on this case is that part of the reason that the court had so much trouble with the analysis is that it didn't want to determine whether whether the university as an institution possessed rights under Section 2A. So in my view, this was really a case about institutional religious freedom, about institutional autonomy, but because they didn't argue that strongly, because it hasn't been established in Canadian law, and because the court didn't want to go there, it ended up just being about kind of the right of individual students to prefer to study with people who shared their beliefs, and that wasn't good enough, basically, to justify these equality infringements. Okay, and so these are just, I think, this is my final slide, some questions that we're left with in Canada, which have been explored to greater extents in other jurisdictions, and something I'm taking up in a piece that I'm writing, which is forthcoming in the University of Toronto Law Journal. So I'll stop there, and hopefully we can take up some things in question period. Thanks very much for having me.
Галина Михайловна, у вас микрофон выключен.
Sorry. Thank you very much, Kathryn. Thank you, and I'm sure that we'll have questions, because there are very many interesting issues which are interesting and very special. Sometimes they seem to be common for us as well. So I just want to welcome Andrea Pin, who joined us from Padua. Andrea?
Hello, thanks for having me. Sorry, I was late.
Thank you, no problem. We are very glad you made it. So thank you for coming. Now, Mark is the next, and then Andrea, I'll be the last one, so Andrea will be next.
Thank you again, Gaia. And I should have said before, I also want to congratulate Professor Davidian on the center that she's established at Lomonosov, which already has, of course, a world-class reputation. But these issues of comparative law and religion, in my opinion, are among the most interesting discussions in law and religion. And really, it's a way to advance knowledge to do these events. And so those of you who are students at Lomonosov, and I think I recognize 1 or 2 of you from my past speaking engagement here, you're very lucky to have this center. And I just wanted to say that also.
Thank you.
Well, religious liberty is a contested concept just now in the United States. For the first time in our history, influential commentators question whether religion as such deserves the special protection that American law has always afforded it. Moreover, religion is becoming a partisan matter. That is, pro-religion and anti-religion Americans, if one can say it that way, are sorting themselves between the 2 political parties. Now, we've had religious divides before. Catholics and Jews historically identified with the Democratic Party and Protestants with the Republican Party. But today's divide falls between those Americans who are more secular and those Americans who are more religiously observant from whatever faith tradition. Polls show that most secular Americans, most of whom are socially progressive, support the Democratic Party, while most religiously observant Americans of whatever faith confession, most of whom are socially conservative, support the Republican Party. Now, of course, it's more complicated than that, especially if you break things down by race and ethnic identity, but the divide between secular progressives and religiously observant conservatives seems incontrovertible today. This cultural and political divide shows up in American law as well. And one area where the divide is especially clear concerns education and religious institutions. So I'm talking now about topics that both Lina and Kathryn have addressed already. Most religious Americans believe that the law should allow religious schools, which are private in the United States, to compete equally for public funds and make employment decisions based on faith commitments free from government interference. On the other hand, secular Americans are skeptical. They're concerned when they see public monies go, even indirectly, to religious schools, since they think that blurs the line between church and state. And they worry about allowing religious institutions full authority over employment decisions, since those decisions might mask what secular Americans see as invidious discrimination, especially based on sex or sexual orientation. So legal debates about religious education intersect with the cultural and political debate between progressives and the traditionally religious on sexuality and gender. And in my remarks today, I'd like to describe how this divide revealed itself last term at the United States Supreme Court. In the October 2019 term, the court decided 3 cases with implications for religious liberty and education. And in one way or another, all the cases reflect this wider conflict that I've been describing. And taken together, they suggest the court is prepared to acquiesce in the dominant progressive consensus on sexuality and gender, while allowing religious institutions, including schools, space to dissent. Okay, 3 cases. The first case is Bostock versus Clayton County, which considered the question whether federal law bars discrimination in employment based on sexual orientation and transgender status. In the case, employers had fired employees for being gay or being transgender, and the employees sued under Title VII of the 1964 Civil Rights Act, which makes it unlawful, among other things, for an employer to discriminate against an employee, quote, because of the employee's sex. The court held that this statute covers employers who discriminate against employees for being gay or transgender. An employer who discriminates against an employee for being gay or transgender, the court reasoned, necessarily discriminates against the employee because of that employee's sex. For example, if an employer fires a man who is sexually attracted to men, but not a woman who is sexually attracted to men, the employer discriminates on the basis of the employee's sex. Similarly, if an employer fires a man who identifies as a woman, but not a woman who identifies as a woman, the employer likewise discriminates based on the employee's sex. And the vote in the case was 6-3. Now, the court's reading of this statute was aggressive, to put it mildly, as 2 justices explained in dissent. The court normally interprets a statute according to the ordinary public meaning of the text at the time the statute was adopted. And no one in 1964, and I think few people today, would understand discriminate because of sex to mean the same thing as discriminate because of sexual orientation or discriminate because of transgender status. But I don't wish to focus on the statutory interpretation question here. As one of the dissenting justices in the case said, the court's decision has obvious implications for religious institutions, including religious schools and universities. Let's say that a Catholic school decides, on religious grounds, to fire a teacher who enters into a same-sex marriage or who undergoes sex reassignment surgery. would the school violate federal law by disciplining or firing the employee? Or consider another federal statute that applies to education. Title IX of the Civil Rights Act prohibits any school or university that receives federal funding from discriminating, again, based on sex. So what if a Catholic university refuses, on grounds of religion, to make married student housing available to same-sex couples? Or what if an evangelical college refuses to allow transgender individuals to compete on women's sports teams? Would those actions expose the schools to the anti-discrimination laws? Now, the court in the case last term conceded that questions like this might merit, quote, careful consideration, but the court said they were premature. The court said it would address any conflicts between civil rights laws and religious institutions in future cases. And besides, the court said there were other statutes like the Religious Freedom Restoration Act and also constitutional provisions, which I'll address shortly, that already afford protection to religious believers. Okay, that's the first case, Bostock, the transgender and gay discrimination case. The case, Bostock, in my opinion, suggests that the justices are prepared to accede to the progressive view of sexuality and gender. But the court's hints about these lingering issues imply, in my opinion, that it will afford religious institutions space to dissent. Other decisions from last term confirm that reading. Consider, for example, Espinoza versus Montana Department of Revenue, which examined the constitutionality of a Montana school choice program that allowed parents to direct state-funded scholarships to religiously affiliated schools. And remember, in America, unlike, for example, in Greece, which Lina spoke about, these are entirely private. They're not public schools at all. The amounts involved were relatively modest in terms of money, and the parents could choose to direct the money either to religiously affiliated schools or to non-religiously affiliated schools. The Montana courts ruled that that program, the scholarship program, violated the state's constitution, which prohibits the appropriation of public money for, quote, sectarian institutions, close quote, including private religiously affiliated schools. The United States Supreme Court, however, held by 5-4 that this provision violated the US Constitution, specifically the First Amendment's free exercise clause. A state may not exclude schools from a funding program simply because of the school's religious status or character, the court said. Once a state decides to give money for private education, the state cannot disqualify some private schools simply because they are religious private schools. That's what the court said. Now, the case concerns school funding programs, but it also has implications for debates surrounding sexuality and gender. Many, if not most, private religious schools in the United States hold traditional understandings of sexuality and gender. In fact, parents often choose to send their children to these private schools precisely to avoid the progressivism that pervades American public education. Allowing religious schools to receive public money equally with secular schools thus could make it easier for the traditionally religious to pass on their values to the next generation. Okay, that's the second case. The third case is Our Lady of Guadalupe School versus Morrissey Barreau. And this is the so-called ministerial exception case. And I think that this case likewise demonstrates the court's willingness to allow traditionally religious schools some autonomy in governing themselves. In a case 8 years ago, the court unanimously held that when it comes to a religious institution's employment of ministers, quote unquote ministers, the Constitution requires an exception to the anti-discrimination laws. That is, the anti-discrimination laws do not apply to ministers, broadly defined as religious teachers and leaders. Under the ministerial exception, the state cannot interfere with a religious body's employment of its ministers, even for the sake of preventing otherwise illegal discrimination. The court has described the ministerial exception as a commitment that follows from the principle of church autonomy. And under that principle, the state cannot interfere with internal church government, including internal management decisions that are essential to the institution's central mission. And I just have to say that the leading case here involves a Russian Orthodox church here in New York called St. Nicholas Church from many years ago. We can talk about it maybe during the questions, or if anybody wants to email me about it, we can discuss it then. It's a very important American case involving a Russian Orthodox church here in New York. Okay, now back to Our Lady of Guadalupe School. In this case, decided just this spring, this summer, teachers at Catholic schools claim to be the victims of illegal age and disability discrimination. And the court straightforwardly applied the ministerial exception and said these lawsuits could not go forward. The court reaffirmed that the ministerial exception covers church personnel, regardless of their formal titles, as long as they perform the functions that the exception is meant to shield from state control: leading a religious institution, teaching on behalf of a religious institution, and carrying out the religious institution's mission. The case involved teachers at two different Catholic schools, neither of which held a formal title as minister, but both of whom performed religious functions, including educating students in the Catholic faith, guiding students in the daily exercise of their faith, so for example, praying with the students, and finally, attending church with the students. Each of the teachers sued for employment discrimination. One said she was fired because she was too old, and the other said she was fired because of disability, but the court said it doesn't matter, the lawsuits could not proceed because of the ministerial exception. Okay, like Espinoza, the public funding case that I just discussed, the Our Lady of Guadalupe School case does not expressly relate to the debate about sexuality and gender, but I think it has implications for that debate all the same. If the ministerial exception preempts anti-discrimination laws that cover age and disability, it logically should preempt anti-discrimination laws that cover gender and sexuality as well. And everyone knows that after the Bostock case, lawsuits with respect to those questions are coming. Inevitably, a teacher at a religious school is going to claim that he or she was fired because of sexual orientation or transgender status, and that the federal anti-discrimination laws should protect him or her. The fact that the Our Lady of Guadalupe School case reaffirmed the ministerial exception suggests to me that the court will be willing to allow religious schools and universities significant discretion in deciding whom to employ, at least whom to employ as leaders and teachers, notwithstanding the expanding scope of federal anti-discrimination law. So I guess, Kathryn, this is sort of going the other way from the case you mentioned at the end of your presentation. Okay, let me conclude. In my talk today, I've described three cases from the Supreme Court's most recent term. I've shown how those cases reflect a wider conflict between progressives, mostly but not entirely secular, and conservatives, mostly but not entirely religiously observant, over the scope of religious freedom, including with respect to education, and over evolving understandings of sexuality and gender and what equality means. Taken together, I think the cases suggest a compromise developing at the court. Progressives will prevail with respect to new understandings of sexuality and gender. That's what the Bostock case suggests. But conservatives will prevail with respect to the autonomy of religious schools and universities and institutions more broadly, and their ability to dissent from these new understandings of sexuality and gender. I think that's what Espinoza and the Our Lady of Guadalupe School case suggest. We'll have to see. This term, both the progressives and the traditionally religious can claim victories. And perhaps that's just what the court hopes to achieve, a modus vivendi in our American culture wars. Of course, some might wonder whether the court should be in the business of resolving our deepest cultural and political divisions. But as Alexis de Tocqueville saw almost 200 years ago, in America, political questions inevitably become judicial questions. And at least with respect to some of our current divisions, the Supreme Court seems confident that it will be able to fashion a workable compromise. Thank you again.
Thank you, Mark. Thank you. It's very interesting. And I was listening to you and thinking that we are living in such a different worlds because we have cases in the constitutional court like those, and it's a very different decisions. Okay.
Well, and that's one of the great things. That's one of the great things about a conference like this.
Yes, yes. Before giving the floor to Andrea Pin, I want to introduce my colleague who is here. He's a co-director of this center. He's directing the part. Our center consists of 3 different parts. It's the Christian law, Islamic law, and Jewish law. And here is the director of an Islam law, Asif. Are you here? I saw you and now you disappeared. Amirov? I can't see him. He was here. Unfortunately, now I can't see him. Here. Just I want to welcome you and say thank you very much that you are here.
Thank you.
And now Andrea Pin, an associate professor from the University of Padua. Andrea?
Yes, here I am.
Hi. Can you please introduce yourself and share with us your knowledge about the law? It's an interesting country, Italy. Where...
I'm likely to be the most boring presenter today, but since Mark Movsesian made a connection, you can blame him for including me. I mainly teach comparative constitutional law with I specialize also in religious freedom and comparative perspective and Middle Eastern constitutionalism. So I've also studied the topics of entrenching God within the Constitution, which is actually what I'm going to talk about. Would you like me to start? Shall I? Yeah. Okay, thanks. I'll be tossing some ideas. Since I do comparative constitutional law, as I said, I have the privilege of exaggerating and simplifying things because we look from the surface, right? So it's a bird's eye perspective. If we take constitutions in general, so if you Google constitutions around the world, you'll find that roughly 116 texts mention God. So 116 texts nowadays mention God within the text. So it's not an exception, even though it's a topic worth exploring. It's a first takeaway from all this, right? It's rather average scenario, but still quite intriguing, and I'll explore why. But if you break down the timeline within which God was entrenched in the Constitution, you'll see that between 1945 and 1989, so 1945 means many constitutional changes around the world. 1989 is, of course, when we could not visit you, basically. You would have 44 constitutions mentioning God. If you take the time span of 1989 to 2020, you'll have 61 constitutions. So the number of constitutions that entrenched God skyrocketed in the last 30 years. And just out of curiosity, I made also a double check, and I checked 1888, which is when the clash between Afghanistan, Soviet Union, and America was over, but there was no significant change. Although this was understood as a sign of religious revival, at least within the Muslim sphere. So when we look at the constitutions, we are talking about a very symbolic texts. And I will address a topic that I think touch upon 3 different layers of particular complexity. One is constitutional politics. The second is the identity politics. So the idea of that identity has become a common way of framing political discourse and even legal discourse. The third is the interplay with fundamental rights and human rights. If we look at the reasons for which God was entrenched in the constitutions lately, especially in the last 30 years, and more so in the last 10 or 15 years, I think we would find some trends. first would be a way to connect with the past. The second would be an alternative way through which a political order tried to legitimize itself. An alternative way to liberalism, or at least to reconcile different legitimations of the same political order. I'll come back to this later. The third is that the third reason is that was an easy way to have some other reforms passed. So you table both the mentioning God and other reforms to facilitate other reforms passing. Fourth, it is a way to express the fabric of society. So people want to express who made them, what they attach most to, etc. The fifth is a defense from rising minorities. And this is also an aspect that is deeply related with immigration and emigration phenomena. So interestingly, behind this process of entrenching God within constitutions, you see new entrenchments of ancestry, heritage, a perception of threat. So people willing to entrench God because they perceive their scenario, the overall legal scenario, as a threat to their own identity. They want to protect themselves from minorities. And all of this, it seems to me, is not simply a relic of a past. We can talk about the last 10 or 15 years of entrenching God within constitutions, as we were looking at the Irish constitutions of the 30s, that was clearly enacted also in opposition to the Anglican United Kingdom, or other constitutions around the world, including Greece, but I won't speak of that because there are other people who are much more expert than I am. So which are the effects of such changes? Well, all this depends, much of this comes down to judicial review, right? So what is the role of courts? What kind of role courts will play in interpreting these mentions? And much of this has to do with judicial personnel, the selection of judges. It's not a chance that one of the most heated controversies within the EU now is the selection of judicial personnel in Poland and Hungary, which certainly emphasize the religious element within their constitutions and within their political culture. So I don't think this is an accident. It's a multi-layer issue, but it's there. This topic is there. And there's an additional layer problem, which is the binding force of supranational organizations' decisions. So large portions of Europe are within both the EU and the European Convention on Human Rights scenario. And how supranational courts will react to that can trigger more steps, which we will likely envision in the next decade. Coming to what I think is the deep meaning of these changes, I think that these changes make sense. So do make sense. I'm not saying that they are appropriate. I'm saying that there's a reason for them. Because there's a deep sense that political orders need legitimation. And liberalism has provided a rather weak legitimation for them. We discussed this topic time and again with Movsesian, of course. But that is a huge topic everywhere. Can the idea of freedom provide us with a sufficient basis to live together and to accept disagreement, as Mark said before? That's a topic that has been investigated, but we haven't come out with a response that really that's really sufficient to the claims of those who want to entrench God within the Constitution. Another scenario which is much related with this is that the new rights agenda, controversial rights, or rights we can either disagree or agree with, is often misunderstood as being the backbone of liberalism. So you are a true liberal, you are a true defender of liberal thought and of constitutional democracies and liberal democracies if you defend some strands of rights that for some portions of society are controversial. So how do you defend yourself? One of defenses is entrenching God, making the Constitution a symbolic way to go public for you. And last, I don't think this is a only minor issue. The idea of God often echoes the idea of a past, the idea of what constituted a community in the past. And one of the weaknesses of contemporary liberal orders, I think, is that they fail to connect with the past. So they emphasize so much the role of progress, the idea of progress as an unfolding reality. So we will inescapably reach more freedoms, we will be liberated from the past, is something that contradicts this idea and does not persuade many people. So coming down to, well, I'm coming to the end, I would say two things. One is that this is not just symbolic. For a decade or so, we used to speak of entrenching God within constitutions as mainly a symbolic issue. And even that was considered by many inappropriate, or at least controversial. But now we are seeing political orders that are trying to implement new policies based on the fact that they have God within the Constitution. So Hungary is implementing new controversial policies on homosexuals because, and in the name of the Christianity that they cherish within their constitutional order. So this is not just symbolic. If I were to conclude, I will conclude with what Marx said at the end of his speech. So he emphasized the necessity to balance competing views and even the controversial role that courts can play, right? And I think that we are facing with a very, very interesting dilemma. We have constitutions that, according to some interpretations, foster new rights and rights that half a population or so may find some controversial. But the same societies were able to entrench God within the Constitution. So to some extent, we entrenched weapons within the Constitution. So the risk we are running is weaponizing the Constitution, either in favor of some rights or either in favor of some other rights, in a way that it's really unpredictable to me at this stage. I'll stop here. I hope I tossed some interesting idea on the table, and I'm glad we'll be able to discuss it further.
Thank you very much, Andrea. Yes, of course, it's interesting because we see so many different ways of references to God and different stories, how it's, and I'm thinking about this problem and finding out that Russia is a very special country with a special way and understanding of everything. Now, if you allow, I'll try to be short about the the same, can the God be constitution? Well, of course, I'll speak about Russia. Because you know that, as you know, that this year our conference is dedicated to the amendments to the Constitution of the Russian Federation, the whole conference. We had more than 2,000 participants. Today we have more than 20 roundtables and sections. And the whole constitution was about the amendments to the Constitution of Russian Federation, which took place in July of 2020. These amendments sparked discussions in our civil society, in academia as well. But I want to mention that these amendments were supported by the popular vote, and 77 and 92% of the population voted for the amendments. Of course, it doesn't mean that everybody were for. I voted too, but I'll not disclose how. For example, Nenets Autonomous Okrug, it's a Safar, I think, east, they voted against. But Chechnya, 96% voted for. So, but 77 and 92, which means that there is a support from the population, from the people of Russia for these amendments. So as a result of changes, we got an Article 67.1, and the second part of this article reads as: the Russian Federation, united by a 1,000-year history, preserving the memory of the ancestors who passed on to us ideals and faith in God, as well as continuity in the development of the Russian state, recognizes the historically established state unity. So this is a new article, and we got the God firstly in the Russian constitution for the last 100 years, first time after the Russian empires collapsed and the Soviet Union collapsed. Before the popular vote, the president of Russian Federation asked the Constitutional Court for the interpretation of these provisions, and the Constitutional Court established that the proposed norms are non-political, non-partisan, and non-confessional in nature, and cannot be regarded and applied as establishing a state or mandatory ideology, changing the principles of pluralistic democracy and secular nature of the Russian state. And especially about the provision 2 of the new article, the Constitutional Court gave the interpretation that this Article 67 and .1, it does not mean a rejection of the secular character of Russian state, and proclaimed in its Article 14 a freedom of conscience. It means free exercise, guaranteed by its Article 28. So it doesn't declare the presence of certain religious beliefs mandatory in Russian Federation, does not place contrary to other articles of the Constitution, and citizens of Russia are not in an unequal position depending on presence of such faith and its specific orientation. So the Constitutional Court established that everything is good, but unfortunately I can't agree with the position of the Constitutional Court. Everything is good, but there are some moments, and we have to find out. All of our speakers today were drawing our attention on what are the reasons of referencing to God, or what's going on in the United States, what's going on in Canada, and we saw different models of the regulations, and can find out that, as Andrea said about that as well, that sometimes the references to God this is a government support for the dominating religion, like in the Constitution of Germany in 1949. I know that there are objections from the constitutional courts of the lands from Germany to this idea, but you can definitely see their support for the dominating religion, like in Greece. Or sometimes the reference to God is legitimizing the secular power, like in Russian Empire, or defending the common values, or tributing the traditions, like in Armenia. Constitution of Armenia of 1995, which was amended in 2015, there is an article with a reference to God, but it's quite understandable because there was no state in Armenia for many, many years, and the church was the only organization which saved the nation, the culture, the language, the religion, and that's here we can see that the constitution is just underlining the traditions of the relations between the state and the church. But the Russian model, I think the Russian model of 2020 is a little bit different. What's the difference? Let's look to the reasons of difference. Of course, it's my opinion. This morning I was speaking with one of the authors of these opinions. It's Professor Avocat, who is head of the Department of Constitutional Law at the Law School of Moscow State University. I said that this is my idea. He said, no, you are not right. The idea was just to underline the traditions, nothing more. But what I'm thinking, first of all, let's look into history. The relations between the secular and church authorities in Russia were quite smooth. You know that in Western Europe, there was a dualism between the authorities. In Russia, everything was very smooth. Not very smooth, but it was quite smooth. The church supported the secular power, explaining its origin by the will of God. In its turn, the secular authorities were very supportive of the church. Starting from 1684, in the first codified Russian act, the Cathedral Code, and until the last criminal code of Russian Empire, crimes against the church were in the first place. These crimes were considered be extremely dangerous and were punished harshly. And the relationship between the church and the state changed slightly during the Peter the Great. He eliminated the church independence, united the secular and spiritual power, and became an emperor, the first head of secular and spiritual power in Russian Empire. However, neither Peter nor the subsequent monarchs interfered with the canons and dogmas of the church. The internal government of the church, sometimes even property issues and others, were purely in jurisdiction of the church. And according to the Russian legislation, the Russian Orthodox Church always had a privileged position. For example, this was manifested in different facts. For example, the emperor had to be Russian Orthodox, or only the Russian Orthodox clergy were involved in official capacity in the most important events of the state and the public life. Only the holidays of the Orthodox Church were officially celebrated. The marriages between Orthodox and not Orthodox people were under pressure. The non-Orthodox spouse signed a statement that he would not pressure the Orthodox spouse to convert, and they would bring up the children from marriage into the Orthodox faith. And there was a very famous slogan in the Russia of 19th century: orthodoxy, autocracy, and nationality. First, it was in the system of education since 1835, and then it was covering the government institutions and the government life later, since the revolution. And in 1918, after the October Revolution, the church was separated from the state, and it was quite limited in rights, very much harshly controlled by the state. The only episode when the state and the church were together, it was the Second World War. We called it Great Patriotic War. But after that, the church was in a bad position. It was separated, but always controlled by the state. This situation changed after the collapse of the USSR in 1991. We got the second argument, and the second argument is a judicial argument. So in Russian constitution and federal law, we got good ideas, which we had before, but now a guarantee of free exercise, a guarantee of freedom of religious associations, but we still have criminal and administrative law defending the religion, which sometimes reminds me of the 19th century. There is an article in the Criminal Code of Russian Federation which says that I don't think that it had been used very often, but it is about the feelings of the people who believes into God, and any violation of these beliefs can be punished as a crime. And if we'll exercise if we look onto the judicial cases, the practice of the Constitutional Court and the Supreme Court will not find very many cases about the limitation, for example, religious rights in education. They are, of course, we have cases in the European Court of Human Rights as well, but most of the cases, they are complaints of the small religious groups, not the traditional religious, not the tradition, not Islam, not Judaism, they are not coming from the Buddhists, they are coming mostly from the small religious groups, which are very often recognized here as illegal or unconstitutional. Yesterday, the whole channels were reporting about the searches in the Jehovah's Witnesses office. The Jehovah's Witnesses were recognized by the Supreme Court of Russia in 2017, I believe, yes, as an extremist organization. But we still have these witnesses in Russian Federation. I believe they had more than 395 local branches in different parts of Russia. And yesterday there were still searches because I think the authorities saw some activities. Here is a part of the decision of the Constitutional Court from the case of the slavery army. I don't remember the exact name of the organization. It's a small religious group which came to the Constitutional Court with a complaint on the violation of their free exercise clause. And the Constitutional Court established that based on the need for effective implementation of the above constitutional provisions, taking into account the nature and level of threats to state and public security from religious extremism and terrorism at the present stage, the federal legislature is entitled to establish not only the grounds, conditions, and procedure for carrying out measures to combat these antisocial phenomena, but also set measures of political, social, socio-economical, information and propaganda, organizational, legal nature, which relate to the measure of general counter-reaction to them, which means that a constitutional court often agrees with the state that the small groups, most of them are Christian groups, the religious groups which are not traditional, They are bringing elements of the extremism, sometimes terrorism, in our life. So the judicial argument is that the courts and the legislation, for example, in the federal law, the understanding of a religious group is so poor, so narrow, that it's very hard to say what means religious group, how they can exist. And it's the reason why the courts can easily recognize the violation of law, and they cannot recognize the religious group as a group existing in our civil society. And the third reason why I think that this is not just a tradition, the reference to God, that we have to look to the whole complex of the amendments. First of all these amendments came not to the preamble, but to the third part of the Constitution, which is about the federalism, which is about the main provisions are about how we are building the federal government, first of all. And the next is this reference to God appeared with the other conservative values, with the Russian language as a language of a state-forming nation, with the family as a union of a man and a woman, with memory of the Great Patriotic War and others. And I think that reference to God as an amendment to Russian Constitution is just a message of the state to the population about the preservation of all values, of all foundations, and about mentioning, establishing that we will stay on this and will not change anything in our society. What is the future? I think that you spoke, Andrea, about this too. What is the future of this reference or these amendments? I mean, can the court of the general jurisdiction use this provision of a constitution? I think not. I don't think that there'll be any use of the general courts, but I'm sure that the constitutional court, when we'll have some problems rising as a contradiction between the position of the constitutional court or Russian constitution and the European Court of Human Rights, can easily go to this reference to the court and say that we have this provision and there is a contradiction in your position, so we can't follow and fulfill your decisions here in Russia. Thank you very much for your attention. I have to mention that this is my position, my own position, which I discussed today with one of the authors of these amendments, and he said that my understanding is not right, but I think that we are doing not as a politics, we are not doing not as a lawyers in academia, and we have right to express free expression, which is one of the provisions of Russian Constitution. Thank you very much, and let's go to the discussion of the different positions, national ideas, and religion and law. So I think we will start with the questions to the different speakers, and then maybe some of us will give a summary of the different.
Professor Davidian, I have some commentaries, if you allow me.
Yes, of course.
Ayana. I'm Asif Amirov, Associate Professor of the Chair of Commercial Law, Associate Professor of Philology and Law, one of the assistants of Professor Davidian in religious research work in our faculty. I'd like to tell you some words concerning religious, concerning legislation, and concerning law. I have nothing to add to the speech of Davidian and the others, and I appreciate the organization of this round table, and I salute all the participants, colleagues, and students and others. I can tell you only 2 minutes, I'll take your time, that Russia, as you know, is the country of constitutions. The year of, in 100 year, there were 5 constitutions of 1918, 25, 37, 78, and the last one, 93. And in all these constitutions, the name of the God was not introduced. But the last one, amendments. And it means that in America, in 1787, one constitution was adopted. And up to this time, more than 200 years, the country is very stable. And Russia is the country of revolutions, and the name of the God was excluded from our memory, from our life during 75 years. But I remember my father and my mother. My father was secular and my mother was believer. And I am also secular. And the last constitution, 1993, as Professor Davidian has already told, in the amendments to Article 67.1, declares that our ancestors passed us the values and the belief in God, the word God with the capital letter written. And this is also valuable and very important, that the Constitution itself includes this norm, and it will make our Constitution more important, more valuable for the future. But up to now, as Professor Davidian has already told, some legislations mentioned, for example, one of them was that the 7th of January, we celebrated the Christmas Day.
The whole country.
Religious Day.
Yes, the whole country.
Yeah, and some documents, criminal law and others, declared punishment for the violation of sense of the believers. Sense of the believers. That I think that this last amendment made in our Constitution, Article 67.1, that our ancestors passed us ideas, values, and one of them is Vera of Bog, belief in God, the God with capital letter. In future, that everything will be changed in Russia, and we include into our spiritual life also the word of the God. God bless us. Thank you.
Thank you very much, Asif. So, any questions, ideas to the old speakers? No questions? Interesting. Maybe you are too. I don't see.
Can I ask a question?
Yes, of course, Ivan.
Well, hello everyone. My name is Ivan. I'm studying the master program of the comparative law, the first course. Thanks to everyone for this roundtable. I have 2 questions. First one to Mr. Kaniewski, and the second one to Mrs. Chan. The first one to Mr. Kaniewski. Well, thank you for your speech. It was really interesting. And talking about the interaction of secular law in Israel, in today's Israel, and Jewish law. So if we take into consideration the correspondence of Israel law and Jewish law, in some way it's absolutely correspondent. So part of Israel's legislation is correspondent to Jewish law. For example, let's take the amendment to the law that punishes both the bride taker and the bride giver, regardless of the reason they commit this crime. And this, in this part, there is correspondence. Correspondence of Israel secular legislation and Jewish law. And from your point of view, does the secular law get some religious traits. So we can see that the will of God, it appears in the secular law in the text without appeal to the God, but the will of God, it appears. Or from your point of view, secular law just covers the religious law and stays only secular.
I think, Ivan, the questions must be short because I forgot the first part of your question. But the idea, but I understand the idea. Anton?
I can summarize.
No, Anton.
Okay. I'll answer short.
What's the question? Okay.
And in Israel, it's obviously extremely complicated. I would say that the answer to your question depends on religious views of a judge who would answer if this appears, or a rabbi who would answer this question. As I tried to show, one might claim that absence of express reference to a religious source might make a law that in fact fits exactly the religious requirements, might label this law as non-religious or even against, legislating something against the religion. On the other hand, obviously a more moderate view would say that a secular law that repeats or restates a religious requirement is a solution absolutely acceptable from the religious point of view. And the legislator obviously generally would claim that this is always a step towards religious beliefs. Thank you.
Mm-hmm. Yes, Ivan, and the second question?
Yes, thank you for the answer. And the second question is to Mrs. Chan. Mrs. Chan, you mentioned the non-state legislation system. For example, let's take Sharia courts in Ontario that were established but then were abolished soon. And from your point of view, which difficulties did the state of Canada face with this legal institute? What are the pros and cons of it? And will the experience of this non-state legislation system, will it spread among other countries? Thank you.
There we go. Unmuted. Thanks for your question. The Sharia courts I didn't talk about were, have been established in, were established in Ontario and became a big political issue, as you seem to know about, though I didn't talk about it. And of course, there are other less prominent religious-based tribunals throughout the country. You know, what happened in Ontario was that the expert who was actually called to write the commission about it was supportive right up to a certain extent of their use, and then politically that wasn't a satisfactory answer. It's kind of the very short version of the story, right? And so I think that our law, our constitutional law, has space for the outworking, the existence of these kind of religious tribunals to a certain extent, right? But we also have a very strong, not just legal protection, but very strong culture of equality rights in Canada. And so the ways in which those tribunals I think impact on the rights of individuals within those communities, and I use that word rights right loosely, right? Because people can have different views on what that means within a religious community. There's also very strong views held with regard to the importance of those individual rights, and so there's a kind of constant push-pull tension that we also see, and I guess I can't go into it too much, but I guess what I'll say is one of the places where that's working itself out in a different context in Canada has to do with Indigenous self-government, right? And so we have a strong Indigenous self-government movement right now, a lot of action and work being done around that. And there's an interesting relationship between those developments and the developments or the question of the self-government of religious communities that continues to work itself out. So it's a live question right now. They're not very prominent in Canada. Yeah.
Okay, thank you very much. I saw there is a question to Mark.
No. Thank you. Again, if you permit, I think that what Mark finished his presentation with envisioning a kind of balance that is now might come into play with the ability to preserve the autonomy on one hand and progressive understanding as being generalized and everyone would be obliged to recognize progressive interpretation. But I was fascinated by the minority opinion in the case Kathryn brought up, where the judges Moldova and Cote, I think, they said that indeed grisly spirit might deserve protection, and the only problem was purely of economic kind, that as far as I understand, if the land would not be that expensive, those judges might have say that indeed religions should be the main, the religious claim should be the main. So I wonder, and this seems to suggest that there might be an alternative model of balance. And I wonder, do you think any practical alternatives to what you see, to what you described as what's going to be in the meanwhile, in the future, or in theory at least, alternative modes?
Okay, thank you. Well, of course, I can't speak to the case that Kathryn was discussing. I don't know it, although I will say, Kathryn, I'm sure you know, in America, we have had similar cases, and I think there's now a law review article coming out in the Harvard Law Review this year just about these Native American rights and how the courts are balanced. But to answer Anton's very good question, let's wait and see, because, so my talk was about last term at the Supreme Court. This term at the Supreme Court, there's a very important case involving a Catholic child adoption agency in Philadelphia, which did not want to place children with same-sex couples. And so the city of Philadelphia then excluded this Catholic agency from the city's adoption services, just said you can't participate anymore. This case is now at the Supreme Court. And one of the questions that the court specifically raised is, shall we apply a balancing test of the sort you are describing, where you weigh the religious freedom against the importance of the state interest? So that is now being litigated right at the Supreme Court this term. We're going to find out this term what the Supreme Court says about it. So one answer I'd have is let's wait. The second answer I would say, and if I may maybe throw this out there, my impression listening to everybody this morning, the real hard thing, it seems to me, is trying to be neutral about these things. I think maybe what we're learning is neutrality is kind of impossible. You know, it really is impossible, because the compelling interest test, or the balancing test that Professor Chan spoke about, says you have to weigh the importance to the religious believer against the importance of the societal interest. And how do we determine how important the societal interest is? That's not a legal question. That's a philosophical question. And in a pluralistic society like we have in America, people are going to disagree greatly about those questions. As I was listening to Professor Davidian, and she was, I think, Gaia, I think one of your criticisms was that this new constitutional provision in the Russian constitution isn't really neutral. It's taking a position and saying, this is the orthodoxy. Right, but it's impossible to be neutral.
I'll not say orthodoxy, because, you know, I'm speaking with the people from, I have very good relations with from different traditional religions. At the law, they say that they are having very good times in Putin's Russia. So not the Islamic religion or Buddhist, they are having good terms, but not the small religious groups.
Okay.
I mean, traditional religions.
Yeah, okay. So with that, okay, I understand. So with that correction, still it's taking a position.
Yes, definitely.
But no matter what happens, the state is going to take a position on what is the correct way to go. So in this balancing test, right, either the court will say the societal interest in ending discrimination on the basis of sexual orientation is extremely important and it must take priority, or it will say the religious view is very important and we have to allow the religious, that you can't be neutral. That's that one way or the other it's going to be decided. So in short, I would say to Professor Kaniewski, number one, let's see what the court says this term in this case. And number two, I wonder whether it's ever going to be possible to achieve some kind of neutral resolution to these questions. Myself.
Thank you. Kathryn, may you add something for the minority view and like?
Yeah, so the Tanaha case is really interesting on a bunch of levels. Part of what's going on that you don't necessarily see just reading the Supreme Court of Canada judgment was that the negotiations over this land started in the 1990s. And it wasn't until 2008 or something like that that the Tanaha said to the government that this spiritual issue is here, right? So it's 18 years. And so and you can kind of, if you read closely in the majority judgment, you can see this kind of skepticism, right, about this claim. Oh, here's, 20,000 kilometers of really valuable land, and suddenly there's a grizzly bear spirit on it. I mean, I'm being a little bit facetious here, but the flip view, I've actually talked to some people from the Tanaha Nation. The flip view is, or the Tanaha view is articulated. Look, we've had a violent, antagonistic relationship with the colonial government since you got here. Why on earth would we give you our sacred knowledge, right? And so their position was, we've always had this knowledge, but we're not going to share it with you until like it's absolutely the last thing. So, right, and I'm sure you probably where you come from, like you can imagine these kind of debates, right? And so I don't know, right, what actually went on in the back rooms, but and what the knowledge of the knowledge keepers was, but you had two very different views. So that's going on too, and the minority is just more willing to say, I think, to believe, to take on face value the position of the Tanaha, which quite frankly is what they should be doing based on their own law, right? Which is in Canada just kind of a subjective, if you say you believe it and it's credible at some level, we're going to just take you at face value. And to say, well, this can't be just about protecting. I mean, if they are right that the grizzly bear spirit is gone, when this is, it's obviously ruining their belief system too, right? They go hand in hand. It's like if you removed a mosque from, a really sacred site, you're not just protecting the mosque, right? You're protecting the people who believe that thing stands for something and attend, and et cetera, et cetera. So I'll just say, vastly different. It goes kind of to what Mark was saying, right? It's not neutral. And not only is it not neutral, there's a vast range of kind of approaches to all these things. And they become just more evident, I think, in the Indigenous spirituality cases, because the belief systems are so far from what the people on the bench understand.
Okay, thank you very much. There is a question in the chat, the group chat, and to every speaker, but I'll address it to Lina and Andrea. It would be interesting to get comments about the refer to religion and or freedom of religion. If the articles of the Constitution in your country completely reflects the needs and values of the modern society of your country, and what amendment should be done in your country in main law in order to make the Constitution more modern and close to the all parts of the society. Andrea and Lina, who wants to go first?
Lina first. Lina
first.
Okay.
Yes, We spoke about that. Yeah.
Yes, as a matter of fact, yes, I have already spoken about that. I would totally agree with Mark, who said actually that the question is, are these legal matters that can be resolved by courts based on legal reasoning, in which we are going to find the right balancing between, let's say, freedom of religion on the one hand and other rights or other forms of equality, like the ones that Mark has already mentioned, like what is gender nowadays, whether it actually has to do also with gender identity or with sexual orientation. These are issues very political in the deepest sense of the word, I would say. And I tend in this kind of issues to hold the opinion that actually courts should defer to the legislator. So I think when it comes to questions that have that involve ethical values or political balancing, I think then courts should actually say we can't resolve the issue. It is the legislator, meaning actually the people who have democratically voted. Having said that, but I agree with Mark with this observation, which I think is very important. To the question of Elena concerning, well, my opinion concerning the Constitution of Greece, I think I have already voiced it in my first presentation. I think the Constitution is relatively conservative and preserving more than it should do the prevailing religion, namely the Orthodox Christianity in Greece, especially when it comes to symbolic issues. Like, I didn't mention it, but for example, the president of the Greek Republic needs to take an oath which is a Christian Orthodox one, okay? And this is problematic because then you have the question, what if somebody who is elected as a president of a republic is not Christian Orthodox? Or should people who are not Christian Orthodox, although they are citizens of Greece, should be excluded? Or should they take an oath to which they don't believe? Or they should not even voice their different religious opinion because, or belief, because then they would be thought of being even traitors of the Greek traditions. Or if I remember the change of the Russian constitution that you, Professor Davidian, spoke about, that our ancestors have brought us this faith to God, etc. So what if somebody does not share this faith to God that our ancestors have? So all these are very difficult issues, because for me what is very important is equality. And I think that if there is something, a status that needs to be protected by everybody, including the courts, is actually the equal freedom for all. So the status of equality and equal liberty. So if somebody has a kind of liberty, then everybody else should have this liberty, and not excluding minorities from liberties that majorities enjoy. So according to my personal opinion, Elena, I think that there are a lot of things that need to change in our Greek constitution. Thank you.
Thank you. Andrea?
Thank you. It's a tough question, of course. So there are two layers that should be taken into account. I can speak as Italian as well as a EU citizen, and the two go together on a practical level. So 70% of our laws actually reflects EU law. 70% of parliament legislation reflects EU law. And in our countries in Western continental Europe, we have a very strong tradition of judicial review legislation. So we are leaning towards American, since that everything becomes very, 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 very judicial easily. Even though many have tried to change the constitution, they haven't succeeded in changing the principles and the fundamental rights of a constitution, but certainly have changed the structure. One of the things that haven't been addressed, I think, and it's more of a cultural matter, is the role of legal interpretation and constitutional interpretation. So much of the controversy we are watching today does not really revolve around constitutional changes, but rather on constitutional interpretations that, to some extent, have cut loose from text. Not necessarily in a liberal or conservative way, but because of the interplay of EU law and national law within Europe. One of the big players and big theoreticians of EU law was an Italian who wrote that EU should repudiate Montesquieu's idea of separated powers. So judges should be able to do the job and integrate European citizens to the judicial process rather than political process. I think that, as Lina said, I think we should respect the fact that some matters are deeply political and divisive, and entrusting the courts with highly divisive issues is not always the right solution. So I am in favor of a more comprehensive understanding what political powers can do. And as even a deeper level, I'll just mention this. I think that many of the narratives that revolve around human rights are issues of recognition. So groups of individuals asking that society recognize them in their uniqueness. And I appreciate that. I am very sympathetic with that. But to a large extent, law cannot do that. We are simply, as a lawyer, I'm not able to empathize with everybody because law is just an insufficient tool. And so in this respect, I think that it is misleading to expect that the law could do the job of reconciling deeply divided society on political and cultural matters just by saying who wins and who loses. I don't like that, either if I won or if I lost.
Okay, thank you very much. And I'll agree with two, of course, last speakers that it doesn't matter what we have in the Constitution. It's very important how it's working. Because I'm sure that the whole liberal countries, they have in Constitution their free exercise clause, the freedom of religion and everything. But it's very important how it's working in the real life, in the practice and the judicial practice, first of all. Okay, there is another question to Mark. The question is, thanks a lot for all speakers. My question will be to Mark Movsesian. Taking from your presentation, historically, Democrats tend to progressive society and Republicans to conservative and religious society. How do you think after the elections, when Democrats will be in majority, will the legislation follow? Is it possible that religion finally can be eliminated? Mm-hmm.
Okay, thank you, Gaia. Well, no, I don't think religion will be eliminated.
This is a question from Dasha.
Dasha, thank you, Dasha. Well, I don't think religion can ever be eliminated. I think religion is something that is sort of inherent in the human person, and so I don't think that. However, if your question is, oh, I see another, here's it, from legislation. So, okay. So, yes, I do think that now, so these fights have been going on for some time now, but I do think the fact that Democrats have now won the presidency in America suggests the fights will continue in a specific way. I mean, I think that there are many progressive Americans who really genuinely think that that conservative religion is is just not a very positive thing in society, and it gets in the way of flourishing, and we should not be so accommodating to it. And let me give you just a little example of what I think might happen. So you may have heard of the contraception mandate. I don't know if you did or not, but this has been a major issue in American law for about 10 years or 12 years now. So in the Obama administration, the United States government passed regulations about healthcare, about employer healthcare. And in the United States, most healthcare is given through your job. And so the Obama administration said that employers had an obligation to pay for contraceptives for their employees. And including, by the way, including religious nonprofit organizations. Okay, now some employers objected to that, and we had a number of lawsuits at the Supreme Court about whether that was constitutional, or sorry, whether that was legal or not. And the court kind of said, no, it was, the contraception mandate wasn't legal. You couldn't force employers who had religious objections to do this. Including one of the objections was from a Catholic order of nuns, the Little Sisters of the Poor, whose what they do is they take care of elderly, sick, and poor people who are dying. That's what they do. And the administration said, well, your employees, you've got to cover them if they want contraceptives. And the Little Sisters said, no, we're Catholics. We don't agree with, we don't want to do that. Went all the way up to the Supreme Court. Okay. In 2016, a new administration came in, the Trump administration, Republican administration. They ended the contraception mandate, right? They said, okay, we're not going to require religious nonprofits to do this. You might think that's the end of the case. It was not the end of the case, because then progressive groups sued on their behalf and said, no, 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 you can't give an exception to this religious group. They have to do it also. Then that went to the Supreme Court, okay? So now there's a new, we say in English in America, there's a new sheriff in town. There's a new policeman in town. Now it's going to be the Biden administration. I think I can predict that they will reinstate the first rule and say, yes, there is a contraception mandate. And so everybody will switch, right? The plaintiffs will become defendants, the defendants will become plaintiffs, and the lawsuit will continue, which is great if you're a lawyer making a living on these cases. But so anyway, Dasha, my point is, yes, I think the fight will continue. And I think it's, once again, it's going to be a very bitter fight that goes all the way to the Supreme Court, and we'll see what they say.
Okay, thank you very much. Because I promised to all our speakers that will be done in 2 hours. Now it's the third hour. Let's have the last two questions, because I'm feeling uncomfortable that I promised you that will be done quickly. There is another question from Olga. Good evening. Thank you for your interesting discussion and presentation. My question is related to the following. The right to freedom of religion is enshrined in Constitution. Can a person refuse to perform their professional duties by invoking the right? For example, a doctor refused to perform an abortion woman, considering that it's contrary to his religion. Who wants to answer? Andrea, I think it's your question because because you are from Italy.
Yes, I expected that. So truth is that
in Greece, is it prohibited?
We need one more seminar, another 2 hours to discuss this question.
I think so. It's very interesting. And the students are very interested.
Does Lina want to go ahead? I'm happy to.
No, she said just that we need another seminar.
No, I understand. I understood that, but I don't know whether she still wanted to give a glimpse. So do you want me to answer that very quickly?
Yes.
Okay. So the fact is that in mid-70s, our Constitutional Court tried to strike a balance between religious freedom, freedom of conscience, and right to abortion, basically. The basic line was that right to abortion is based on health reasons. So every time there's an abortion, it must be grounded on health reasons, even though that's not actually the case. The process has become more and more routinely. And so they decided that both would win. So you can have an abortion and the physician can object. The result is that 90 to 99% of physicians don't want to perform abortion. So gynecologists, so people who are supposed to perform abortions when it's needed, don't want to do that. It depends on the region. So in some regions you can't find somebody willing to perform abortion, whereas in other areas you can find one. The case was taken even at the level of the UN Social Rights Council, which found us in violation. The fact is that so there hasn't been a balance. They have even tried to hire some gynecologists precisely to perform abortions in case they don't have physicians willing to do that. So the solutions are being sought on a very practical ground for a very basic reason. So on the one hand, those who are not willing to perform abortions claim their conscientious objection on the basis of conscience. They say that conscience does not allow them. And men, we're almost Catholic, and therefore most of us don't want to do that. But on the other hand, those who need an abortion would probably have the upper hand if they were to claim that it is for their health. But they are not willing to do that because they're pushing the argument that it's their privacy. They are willing to get an abortion because they want to decide what they want to do with their life. And this makes the argument trickier because the physicians can easily say, okay, I'm not physician anymore because I serve your health, I'm not serving your privacy. So the way the arguments are played out is not really realistic. They're actually shielding their arguments by using privacy and freedom of conscience in a very loose way. So we haven't settled the matter on a legal basis. We have rather tried to settle the matter on a very practical basis.
Okay, thank you very much. I'll share my experience with the limitation of some, or maybe with the rights, with the professional rights. We were teaching professional ethics in Ghana with one of the general counsels of a big New York law firm. And it was Friday. The study days were Thursday, Friday, Saturday, and we taught on Thursday. On Friday, she said, "I'm going." She's Jewish, and she said, "I'm not working this evening. Now I'll not be working on Saturday, so it's Shabbat." And I was a little bit surprised, but she said it's okay, and it's a very normal thing. But it depends how your employee is looking on that. I don't think that all employees are happy with this, but the big law firms, I think most of the employees now have to, I think, take into account the professional duties and the religion of their employers, because it's important. It's hard to imagine in Russia. I don't think that we have even cases at the courts, and we have a case in the European Court of Human Rights when a judge was very religious, and she lost her position, but she was too religious, and she was putting all her beliefs and ideas to the court. That was the reason why she was terminated, and she went to Constitutional Court of Russian Federation, lost the case there, and the European Court of Human Rights, and lost the case there as well. So it depends. It depends of the real situation, how big is the religion in the professional life of the person. So let us go with the two last questions. Daniel, please, very short question.
Okay, so I'll try to do it shortly. So my question is about life and death situations. If, for example, a person is dying and he needs a blood transfusion, for example, and the doctors say that that is the only way to save him. But, for example, his parents are religious, for example, the Jehovah's Witnesses, as I know, they have those rules.
Yes, we have that cases.
Not allowing doctors to do this blood transfusion. For example, this thing. And another one with our modern problems, the coronavirus. Can government enforce the masks, for example? But as I know, in California or something like that, I think it was in California, it was something like a press conference, and people there said that it is against their religion that the God created this wonderful breed, the respiratory system, and that government should not interfere with this, like to enforce wearing masks. So I want to know your opinion if the constitution, like if it is a breach of constitution to make people wear masks or to make force doctors to perform blood transfusions, something like that.
Who wants to answer? Mark, Kathryn?
I can give a quick Canadian perspective on that. We have a lot of, thanks for your question. We have quite a lot of litigation on that in Canada. And the answer is, I would say in very broad brush strokes, that the government can't make you undergo a medical procedure that against your religious beliefs. But there's two caveats, at least two caveats to that. One is if you're going to hurt someone else. So I would put masking in that category, right? In Canada, I think it would almost for sure be justified on the basis of the third party harm that would be created. The other big exception has to, and a tricky area, has to do with children and youth. And we have a very famous case involving a 14-year-old where the court split, right? Really difficult questions for kids who aren't quite kids anymore, but aren't quite adults, about when it is that they get to make those decisions and when their parents get to make those decisions and when the state's going to step in and protect them.
Thank you.
Thank you very much. I saw here Elena. Elena is a graduate of the law school, and she connected me with Mark. So I can't pass her. I'll give her an opportunity to ask a question. Elena, please. She's working here for Thomas Reuters.
Thank you very much, Professor Davidian. Thank you very much to all participants. In fact, I have more comment rather than question. And to be honest, as far as, again, it's a very interesting discussion. I think we are ready to turn to the third hour without any problems, because the subjects are really absorbing. And unfortunately, due to technical reasons, I joined later. But anyway, so what I would like to highlight based on the discussions of these very interesting, highly ethical, spiritual topics raised today by all lectures, I think that today we are all have a very unique opportunity to see the new way of development of correlations. And I think never in history before so close connection between religion and the law worldwide hasn't been so actual and facing so many challenges. I hope that you all agree with that approach. At the same time, I think the issues that were raised today give very deep thoughts about the future development of constitutional law in every country, and more analysis and more in-depth learning about what religion principles and to what extent that can correlate with the legal principles, both at public and private level, and at the same time at the global level, because what we are experiencing now has never happened before. And this situation with, of course, I think, fortunately, unfortunately, the pandemic crisis and all following consequences will give definitely the new direction for the development of regulation relations and collaboration between the law, legal society, and people, social issues and religion. That's kind of general comment that I wanted to say. And thanks everybody for the great organization and interesting participation and raised issues. It's a great pleasure to follow.
Thank you very
much.
Thank you. And Kathryn wrote me note that she have to go. Lina, do you have a question? I saw your lower hand. Or...
I just gave a comment.
Okay, thank you to everybody. My suggestion would be maybe the students will send me the questions. I can send them to the speakers and they can send you short answers and I'll circulate it to the to the students, because when the students wants to learn and wants to ask questions, I'm always thinking that we have to help them with this. And in the end of our discussion, the 3 hours went like this. I want to thank all of you. First of all, my colleagues, in spite of being so far, it was 6:30 in the morning in Victoria. Can you imagine? Yes, and thank you very much for all of you for coming, for participating, for your time. It's very important to us, for us and for our students to see the different points of view, different manner of understanding of religion and law. And I very much hope that some days we'll meet here in Moscow and looking to the beautiful building of the main building of the university, will be able to offline speak with the students and give answers to their questions. Thank you very much to everybody. And dear speakers, if you want publications, we'll translate your presentations into Russian and public in our scientific series, which are coming after this conference. Or we can do a different publication in our law journal, which is a very prestigious journal in Russia. Thank you very much to everybody. And I very much hope that it's not the last meeting and not the last discussion. Thank you. Bye-bye.
Thank you for the organization, Kaya. Thanks.
Thanks
everybody.
Can we at least hope that's the last one online?
Yeah.
Yes.
It's the last one. Yeah. Yes.
Thank you, guys.
Okay.
Thank you very much.
Thank you. Thank you.